Dear student, today we shall discuss chapter 5, Rights in a Democracy. In the contemporary political context, rights of people have assumed great significance. The denial of rights to people has led to struggles in different parts of the world. These struggles have brought about far-reaching changes and blazed the trail for realizations of democratic ideals in many countries. Now, rights, imizo chanvao. So for any person, for any individual, or for any citizens of a country, in order to have a full development or to live a dignified life, one government has to guarantee our rights to the citizens. Now, what are rights? Rights constitute the things that we are morally or legally allowed to do or have. They are justified claims that an individual, as a citizen of a country or state, is entitled to. So these are the claims. The right of Chanvao has been guaranteed by the state, that is the country, and this is preserved or enshrined in the constitution. So for our citizens of a country, he or she is allowed or to have these claims. Now, rights are necessary for well-being and essential for us to lead a dignified life. So for any citizens of a country, in order to have a dignified life, one has to ensure with rights. Now, importance of rights in a democracy. As you have already read, a democratic government gives people the power to choose the government, control it, and even remove it from power if it fails to fulfill people's expectations. So it is essential for people to enjoy conditions that help them to perform the functions mentioned above. They should also have the right to form parties and unions. It is only by enjoying democratic rights that the people can get together or organize public opinion. A single voice cannot change society, but if people unite, the collective might cannot be overlooked by the government. Democratic government are formed by the majority. At times, this power may be exercised to dominate the minorities. If government has to be the government of the people, it must realize that minorities also constitute the people. Therefore, it must provide for safeguard to ensure that minorities do not suffer and that they are able to enjoy freedom like others. Keeping this in view, certain special rights are granted to them by the government. And these rights are enshrined in an inviolable constitutions. Means these rights are preserved in such a manner that it cannot be broken or it cannot be dishonored in the constitution, that is Danpui. The constitutions of a country essentially signifies the law of the land, according to which a democratic government has to function. Fundamental rights. The constitution, that is the Danpui, guarantees certain fundamental rights to the citizens of India. These rights are essential for all-round development of an individual personality. For any citizens of a country, it is very, very important for all-round development that one has to enjoy a fundamental rights. And these fundamental rights is guaranteed by the constitutions of India. And almost all written constitutions of the world, not only India, but even for the rest of the other countries, it guarantees in some form or the others the guarantee of certain basic rights of the individual are the minimum requirements of the successful democracy. So for a democratic country like India, or for any democratic country, it is very important that there should be a guarantee of certain basic rights in order to have a successful democracy. Features of fundamental rights. Fundamental rights are guaranteed to all the citizens of India. So all the citizens of India are given these fundamental rights by the Constitution. They are enshrined in the Part 3 of the Constitutions. So the fundamental rights is preserved or it's written in the Part 3 of the Constitutions of India. These rights are justiciable, which means they are enforced by the courts. So if any agencies, if any organs violate this right, that is fundamental rights, they can be enforced by the courts of law. So that means they are justiciable. Fundamental rights cannot be easily amended, that is changed, as they are part of the basic structure of the constitutions. So the Indian constitutions, in Indian constitution, fundamental rights is part of a basic structure, and this cannot be changed or amended so easily. In order to change or in order to amend it, a special procedure is required to carry out amendment in the fundamental rights. Why were fundamental rights incorporated in the Constitution? Means, why were the fundamental rights made legal in the Constitution? Number one reason is, after living under the colonial rule, that is under the Britisher, for many years, the importance of having rights to lead a dignified life was realized. So during the time when our country, when India was under the Britishers, there was no right or fundamental rights enjoyed or guaranteed by the Constitution to the people of India. So after the independence of a country, in order to lead a dignified life, to have this fundamental rights became the need of the hour. Second one, fundamental rights are different from ordinary rights because they have special status and they are protected by the Constitution as far as fundamental rights are concerned. These rights cannot be violated by any organ of the country. So the so-called fundamental rights cannot be violated by any organs of the government of the country. These rights are equally bestowed on all the citizens of the country. So the fundamental rights are equally given to all the citizens of our country, that is India. Significance of the fundamental rights. The fundamental rights establish a government system where the cruel and unfair use of power by the majority does not oppress the minority. The rights protect deprived sections, that is the poor sections, and individuals against exploitation and oppression, as they are helpful in generating political awareness among people. In a country like India, where millions of people are deprived, poor people, so through this fundamental rights, these people, the sections, the deprived sections of the people, sections are, protected. So in this way, it helped in generating political awareness among the people. Fundamental rights represent the basic values cherished by the people of this country. They protect the dignity, that is the respect of the individual, and create conditions in which every human being can develop his or her personality to the fullest. These rights are essential for the development of an individual's personality. In the absence of these rights, moral and spiritual development of an individual is not possible. Next one. These rights are more protected than other common rights. So of many rights that is enshrined in the constitutions of India, the fundamental rights are more protected than other rights. These rights are justiciable, which means that these rights cannot be taken away, and judiciary gives full protection to these rights. So as far as fundamental rights are concerned, at any point of time, if it is violated or if it is taken away from us, then we can, or the citizens of India has a right to go and sue in the court of law. So that's the reason why these rights are justiciable. Fundamental rights have been classified into the following categories: right to equality, right to freedom, right against exploitation, right to freedom of religion, cultural and educational rights, and right to constitutional remedies. Right to equality is mentioned in Article 14 to 18 in the Indian constitutions. And in Article 14, equality before law is enshrined. So it means here the state, that is a country, cannot discriminate between Indian citizens on the basis of caste, creed, color, sex, gender, religion, or birth of place. So which means any or every Indian citizens will be treated equally. The second one is mentioned in the Article 15, that is social equality and equal access to the public areas. So people may be speaking different kind of languages, people may have different colors in complexions, or a person may be from different caste. Irrespective of all this, everyone shall have equal access to public places like public parks, museum, wells, bathing gardens, and temples. However, the state may also make special provision for women and children, and especially for the people who belong to the scheduled tribe, scheduled castes, and OBCs. Since these sections of the society are socially and economically discriminated against in the past, so because of that, the government feels the need to provide them with means to ensure that they get equal opportunities of freedom as the others in our society. The next one, that is mentioned in Article 16, equality in matters of public employment. That is mentioned in Article 16. So here, people, that is people belonging to the OBCs, belonging to scheduled castes, scheduled tribes, These are the oppressed or deprived section of the society. So because of that, government has reserved 15% in the government sector and government run institutions for these people, that is scheduled castes, scheduled tribes and OBCs. And sometimes the parliament may also enact a law stating that certain jobs can be only filled by applicants who are domiciled in a particular area. Abolition of untouchability. By untouchability, it is the practice of ostracizing a minority group by segregating them from the mainstream by social custom or legal mandate. As you must be aware that in Hindu society, there are mainly 4 caste systems. On the high, the Brahmin, Kshatriya, Vaishya and Sudra. So people who are not part of this 4 caste system, which is known as outcast, they are also known as Dalits or untouchable. So in Article 17 of the Constitution, it is clearly mentioned that the so-called practice of untouchability is abolished or done away with. So anyone, any agency or any people who practice untouchability is a punishable offense. Abolitions of titles. In Article 18 of the Constitutions, this also prohibits the state from giving any titles. Before the independence of a country, the British government created aristocratic class, that is, Rai Bahadurs and Khan Bahadurs were given, but all these were abolished, and that is exception to these rules are military or academic distinctions. For example, in military, people are conferred with different kinds of ranks like captain, major, colonel, lieutenant colonel and so on. So this is exceptions. And it is also important to make note that awards given in the form of Bharat Ratna or Padma Vibhushan, this cannot be used as a titles by the recipients. The next one is right to freedom. Now, as far as right to freedom is concerned, it is mentioned in the Articles 19 to 22. And as part of this fundamental rights, every Indian citizen has been granted the right to freedom. And the freedoms may be in the form of protection of certain rights regarding freedoms of speech, etc. All citizens shall have the right to speech and expression, the right to assemble peacefully and without arms, the right to form associations or unions, the right to move freely throughout the territory of India, the right to reside and resettle in any part of the territory of India, the right to practice or any professions or carry on any occupation, trade or business. But one thing we need to understand that this right, that is the right of freedom, as far as these rights are concerned, it is not absolute. This means we do not have unlimited powers. For the greater good of the people, the state can impose restrictions on our enjoyment of these rights. For example, we are free to exercise our rights of self-expression, but we cannot exercise this right, defame anybody. Meetings held by the people must be peaceful. No one must disrupt law and order or carry weapon with them. Right against exploitation. This right under Articles 23 and 24 provides for the following provision. The abolition of human trafficking. By human trafficking means the illegal sale of or purchase of human beings for the purposes of commercial exploitations, slave trade, or forced labor or beggar. And abolition of employment of children below the age of 14 years is dangerous or hazardous jobs such as factories, example like firecrackers, matches, carpet factories, railways or ports, etc., and mines. Right to freedom of religion. This is mentioned in Article 25 to 28. India is a secular country, and this implies that the state here means the country, does not promote any religion or others. Religion is considered to be a matter of personal belief. So according to this, the state or the country is not going to uphold any religion as a state religion. People are free to profess, follow and propagate the religions of their choice. They cannot be converted into any religion by force. This means that any Indian citizens have the right to profess any faith, belief or religion. However, forced conversion or converting people forcefully is not allowed. Religious instruction cannot be given in government educational institutions. You might have come across in different schools in Mizoram, especially church-run school or lots of private school where moral educations or Bible classes are included as part of the syllabus. So such cannot be practiced in government educational institutions. Religious groups are free to manage their religious affair. Means the state or the government won't interfere in running of any religious groups. So any religious groups are free to run their own religious affairs. The state can interfere in matters related to religion to eradicate practices that are inhuman. Therefore, if the state passes a law to permit Dalits to enter a temple or prohibits the practice of child infanticide, people cannot oppose these laws, claiming that such a law is an unjustifiable limitation on their freedom of religion. So a time comes when the state can interfere in the matters of religion, especially if it has to remove or eradicate practices that are inhuman. For example, if any Dalits or untouchables are restricted from entering a temple, or if anyone is performing child infanticide, in such cases the government has the right to interfere it. Cultural and educational rights. India is a country of many religions, languages and cultures. Therefore, the Constitution provides special measures to protect the rights of the minorities in order to help them preserve their heritage, and this is mentioned in Articles 29 and 30. Any community that has a language and a script of its own has a right to conserve and develop it. For example, our neighboring states like Manipur, Assam, they have their own script, and Here, according to this fundamental rights, that is under cultural and educational rights, any community who has their own script, they have the right to conserve and develop it. All minorities, religious or linguistic, can establish their own educational institutions to preserve and develop their own culture, religion or language. For instance, in our state like Mizoram, we have our own dialects, we have our own culture. So the state encourages, or it also guarantees us to preserve it and to develop it, our own culture, religion and languages or dialects. The last one is the rights or to administer does not mean that the state cannot interfere in case of maladministration. For example, any aided or unaided minority institution cannot deny admission to a person on the basis of his or her ethnicity, language, etc. Such types of cases can occur in different parts of the country because a person belongs to Dalit or untouchable or Harijan. So because of that, student is not allowed to get admission or denied admissions. So in such case, the state can interfere it. Right to constitutional remedies. Rights can be violated by individuals. They can even be taken away by the state. In order to guard people against such possibilities, right to constitutional remedies for enforcement of fundamental rights has been granted, which is mentioned in Article 32. This means rights provide people the means to protect their fundamental rights. Now, according to these provisions, or according to this right to constitutional remedies, if any citizen feels that his or her fundamental rights have been taken away, in that case, we have the right to appeal directly either to the Supreme Court or the High Court for the enforcement of these rights. If a person is found guilty of violating the law, he or she can be punished. He or she can also be told to pay compensation to the people who are affected by the wrong done by him or her. Suspension of rights. In case of an emergency imposed by the President of India, the article, that is 32, gets suspended automatically. And in case the situation demands, the President by a special presidential order can suspend the constitutional remedies, the right to constitutional remedies. However, the suspension of rights is only for a temporary period, not for permanent. And what does the suspensions of rights mean? It means that a citizen can enjoy his rights, but in case a law or policy is made encroaching on his right, he cannot go to the court of law. Suspension of rights means that the rights become non-justiciable for a temporary period of time. So as long as the President of India suspend Article 32, the fundamental rights become non-justiciable, that is for a short period of time. The role of judiciary. Article 13 of the Constitution empowers the judiciary to declare a law void if it is found to be inconsistent with the fundamental rights. Means that according to this article, the judiciary has a power to declare a law that is legally binding if it is found not to be sane with the fundamental rights. And for the enforcement of these rights, powers to issue any order or direction or a writ, that is a form of written command in the name of court, which can be written to any person or authority, including the government, conferred on the Supreme Court by Article 32 and the High Court under Article 226. The individual was given access to legal institution for the indications of his right. And the highest court in the Indian judicial system, that is the Supreme Court, was to perform three important constitutional functions. That is, it was to be protector and guarantor of fundamental rights. So the judiciary responsibility to see that the rights, the fundamental rights which is enshrined in the Constitution, for this the judiciary has to be a protector at the same time guarantor. And the next one is, it was to umpire the federal equilibrium. Means that the judiciary will have to become an umpire as to maintain balance of power between the central government, that is the federal, and the states. It was to act as a check on the executive authorities and enforce the rule of law. As you know, there are three types of organs, that is judiciary, executive, judiciary, and legislative. And here it is to ensure that the judiciary should check the executive authorities and to enforce the rule of law. Article 32 of the Constitution also provides the right to move the Supreme Court by appropriate proceedings for the enforcement of rights conferred by this part is guaranteed. And the next one is, the Supreme Court shall have the power to issue directions or order or writs, including writs in the nature of habeas corpus, mandamus, prohibition, quo warranto, certiorari. This we will discuss. I'll explain to you in detail later on. So whichever may be appropriate for the enforcement of any of the rights conferred by this part. The right guaranteed by this article shall not be suspended except as otherwise provided by this Constitution. Thus, the responsibility for the enforcement of the fundamental rights lies with the Supreme Court by virtue of Article 32. The general principle is that any person whose fundamental right is violated can seek remedy under Article 32 of the Constitution. And to be actionable, it is not necessary for actual infringements of the fundamental rights to have occurred. Means against someone's right, infringement of the fundamental rights to have occurred, a petition can be moved if there is an imminent danger of infringement of our fundamental rights. A person whose rights have been violated has a right to directly approach the Supreme Court or a High Court for a judicial rectification, redressals of grievances, and enforcement of fundamental rights. enforcement of rights. The Constitution guarantees many rights to the people. These rights hold no meaning till means are provided to enforce them. So now let us discuss some ways in which the rights given to the people can be enforced. Writ or prerogative writ. By prerogative writ means it is a writ that is official order directing the behavior of another arm of government or court. And there are 5 types of writs which are issued for this purpose, and these are briefly described below. Number 1 is habeas corpus, and by habeas corpus, here the term habeas corpus is a Latin word which means you must present the person, and the writ of habeas corpus is issued to a detaining authority ordering the detainer to produce the detained person in the issuing court along with presenting the cause of his or her detention. So for example, if a person is arrested or locked up by police, then it is a duty of the court to order the person who has arrested the culprit or the person by presenting the cause of his or her detention or the reason why the person is being arrested. And if the detention is found to be illegal, the court issues an order to set the person free. The next one is certiorari, and by this name it is also a Latin word meaning to be informed of or to be made certain in regard to. And this writ is issued to a lower court directing that the record of a case be sent up for review together with all supporting files, evidence and documents, usually with the intentions of overruling the judgment of the lower court. And it is one of the mechanisms by which the fundamental rights of citizens are upheld. The next one is mandamus. The term mandamus is also a Latin word, means we command. This writ is issued to a subordinate court, an officer of government or a corporation or other institution commanding the performance of a certain acts or duties. The next one is quo warranto. It is a medieval Latin term that means by what warrant. And this writ is issued against a person who claims or usurps a public office. Through this writ, the court inquires by what authority the person supports his or her claim. The next one is prohibition. And this writ is issued by the higher court to a lower or subordinate court, prohibiting, stopping them the latter from taking up a case because it falls outside the jurisdictions on the lower court. Thus, the higher court transfers the case itself to the higher court. PIL, that is public interest litigation. People get access to courts through public interest litigations, that is PIL, because it provides them speedy and inexpensive justice. It is not necessary that the aggrieved person move the court of law for the enforcement of his or her right. For this case, any citizen or even an NGO can make an appeal to the Supreme Court against any measure adopted by the government that violates another person's right. The court will take up the matter if it thinks that it is in public interest. Independence of judiciary. A fair and independent judiciary is a cornerstone of a democratic system of government, and the Indian Constitution lays down certain provisions that make the judiciary an independent institution. And they are separations of powers, appointment of judges, removal of judges, contempt of court. Separation of powers means the judiciary is separate from the other two organs of the government, that is the legislature and the executive. And as far as these three organs are concerned, they are all autonomous. And the next one is appointment of judges. The judges of the Supreme Court and High Courts can be removed by following the process of impeachment, just like the President of India. And the last one is contempt of court. The judges cannot be criticized openly for the decision. Anyone who disobeys the authority of the court can be punished under the contempt of court. Well, student, I hope it may be very helpful to you. However, for a better understanding, I would request all of you to refer to your textbook. Please read it carefully, understand it, and if you have any doubt, please don't hesitate to ask me. And later on, we will be giving you some assignment for which you will be told to do it. Thank you.